We're going to be looking at duty, and in particular dealings with units in unit trusts today. So the conventional wisdom is that any dealing in units of a unit trust that owns dutiable property in Queensland is going to be subject to stamp duty in Queensland. And I'm here to say that that's wrong. As a bit of a background, duty in Queensland is charged on dutiable transactions, and dutiable transactions are broadly dealings with dutiable property, dealings in partnerships and trusts, the creation of trusts over dutiable property, and certain other deemed transactions which are deemed subject to stamp duty. Now, dutiable property in Queensland means land in Queensland, assets of a Queensland business, a certain deemed item of property or dutiable property called an existing right, a transferable site area, and certain chattels in Queensland. And interestingly, if we're going to be dealing with any of those pieces of dutiable property in the normal sense, such as a transfer, those will be subject to stamp duty, and you'll pay duty on the unencumbered value of the asset as transferred. When, however, we're looking at units in unit trusts, the traditional view that if you transfer units in a unit trust to a new entity where the original unit trust owns dutiable property, that will still be subject to stamp duty, but because of the way that the Duties Act imposes duty, it does give rise to certain planning opportunities and certain duty advantages in dealing with units in a specific way. So let's have a look at an example. In the first example, we've got a discretionary trust which owns 2 units in a unit trust, and that unit trust in turn owns $2 million worth of land in Queensland. If discretionary trust A transfers a unit to discretionary trust B, so that discretionary trust B now owns 50% of unit trust 1, that is going to be subject to stamp duty, as discussed, and there's no real question about that. Because discretionary trust B is acquiring 50% of the units in the unit trust, the dutiable value is calculated by reference to 50% of the underlying property in Queensland, being $1 million, giving us a duty consequence of $38,000. If, however, we do something different with those units, that can lead to a more advantageous duty consequence. That is, if instead discretionary trust A declares it holds one of its units in unit trust 1 on trust for discretionary trust B, then the duty analysis gets very different. Effectively, there's no duty. The reason being that dutiable property, as I discussed before, does not include units in a unit trust, or particularly units in a unit trust that owns land in Queensland. How these transactions are taxed are, depending on the circumstances, either under the head of duty on the creation of a trust over dutiable property, or alternatively under the trust acquisition head of duty. Now, in this situation, because we've already established that the dutiable property excludes units in unit trusts, there is no creation of a trust over dutiable property, meaning that there's no stamp duty consequence on that head of duty. If we then go and look at the trust acquisition, depending on how discretionary trust B's trust deed is worded, that ought not trigger a trust acquisition, because discretionary trust B could potentially not have a trust interest in unit trust 1, which is the key point of being able to charge duty on a trust acquisition. The overall meaning of that being that there is no duty on this acquisition, notwithstanding we now have discretionary trust B in effective control of one unit, as we had in the previous example. If you have units in a unit trust and you're looking at any dealings with them, there are the potential to save some stamp duty if you get us in soon enough. We provide a broad range of advice in regards to duty and duty planning, along with general tax advice and pre and post-sale implementation of tax structures. If you'd like any further advice on this particular transaction or this presentation, please feel free to contact us.